The EU and Great Britain agree the planned British Internal Market Bill violates international law in parts because it contradicts the Brexit agreement, the so-called Withdrawal Act. And now the UK government is proposing a single market law that partially runs counter to the exit agreement with the European Union. Not only does the statement come from Brussels, but the British government also admits it. Northern Ireland Secretary of State Brendan Lewis said in Parliament on Tuesday that the law violates international law in a very specific and limited way. The obvious question of whether the British government can just do it like that has been answered in its own way. It does. But another question remains, does this have legal consequences besides political consequences? And if so, which ones? The British daily The Guardian and the AFP news agency now report that lawyers from the EU Commission have examined legal steps against the British plans. Several scenarios are conceivable. The EU and Great Britain have agreed a special dispute settlement procedure for disputes about a deviation from the Brexit agreement. That starts with consultations. In case of doubt, an arbitration panel can be called in, which in turn can refer to the European Court of Justice. The decision of the panel are binding. It can also impose fines. If one side does not adhere to the arbitration award, the other side can suspend its obligations from the withdrawal agreement or from the intended agreement on future relations. For example, the EU could suspend payments to the UK pension fund. In certain exceptional cases, the EU Commission could also initiate infringement proceedings against Great Britain. Such a procedure also begins with an exchange of views between Brussels and the state concerned about the possible violation of EU law and how this could be rectified. If no solution is found, the EU Commission can take the country to the European Court of Justice. At the end of such legal proceedings, a state can be sentenced to pay a fine. It is also conceivable that British court would be confronted with the question of which law it should apply: the rules of the withdrawal agreement or the contradicting provisions of the British Internal Market Act. On the one hand, the withdrawal agreement clearly states that its provisions apply immediately and that British courts must give them priority over conflicting national regulations. On the other hand, the British law that ratified the withdrawal agreement, that is incorporated into British law, states that the British Parliament is sovereign. But does sovereignty mean in this context that the British Parliament can pass laws that contradict the agreements with the EU? The British court would then have to answer this question. Legal proceedings usually take a long time. Anyway, both arbitration and infringement proceedings begin by attempting to resolve disagreements without an arbitration award or judgment. In the end, the consequences will therefore be more of a political nature and not drawn in court, but at the negotiating table. Although the courts still will play a big role, because there's one thing people often forget. In case of dealings with the withdrawal agreement, the rule of the European Court of Justice does not end on December 31st with the transition period. And if you now want to know more about European politics, YouTube has chosen another of my videos right here for you in the end screen, right next to your chance to subscribe to my channel. I just joined Patreon too, and if you want to support my channel even further, have a look in the description, there's a link for you. I'll see you in my next video, click and enjoy. Viel Spaß!